Welcome back everybody to Land Law. In this lesson we are continuing talking about some of the more introductory elements, some of the sort of introductory issues that we can explore, focusing in this lesson on the types of property which exist. Now this isn't going to be a lesson on the types of property pertaining to, for example, housing. So we're not talking about the distinction between a detached and a semi-detached house or a bungalow. We're talking about the types of property that exist in law, talking about how law treats different property depending on a few key characteristics. We'll look at the distinction between real property and personal property in this lesson, as well as the civil law tradition of movable versus immovable property. So the previous lesson looked at the question of what land actually is and where we can actually essentially delimit the beginning and end to where land actually is. This is often done through the examination of a vertical extension of land. So how high do you go and still have property rights versus how low can you go and still have property rights? This lesson is going to turn our attention away from the concept of the concept of land to the concept of land law. So talking about not only what land is as a physical entity, but what does the law treat as land? And how do we delineate in law between land and different other kinds of property? Now, this is important because some core modules that exist in this particular area, depending on which university you go and study law at, may not treat this as a subject on land law. They may call this property law, and I've always been of the mind that land law is a better interpretation because property law could be a more all-encompassing set of lessons dealing with not only the idea of land, but also the idea of other elements of personal property, like chattel, for example. So as a result of which, I've been calling this series a set of lessons on land law. So we're looking at what land law entails, and we have to make a distinction that is made within the common law tradition of England and Wales between the idea of real property versus personal property. So in English law, this is how we make a delineation between the two major types of property. We sometimes also count intellectual property as a third kind of property. That is only in the sense of how we study these different areas of property law. So you may have a module on land law, you may have a module on the law of personal property, and then you may also have a module on intellectual property law. But that's not necessarily how it is defined and delineated in that kind of way, because intellectual property could also be placed into the category of personal property, at least in the way in which the English law makes this delineation. So we have this distinction here between real property and personal property, and this is not the same distinction that exists in other kinds of jurisdictions. So in England and Wales, we have this idea here of real property versus personal property. Real property is defining things like land. So things like real estate, for example, and personal property defines things that are, well, as you would probably understand, to be personal property. My laptop, for example, or chattel, even things which are not necessarily corporeal, so things like stocks and bonds, securities in a corporation, and even intellectual property, so things like copyrights and patents. But other jurisdictions make the delineation in a different way. They make a distinction between what they describe as movable versus immovable property. And this is a lot more simple to understand and is a nicer way of delineating it. And it is essentially how you would describe it if you were talking about this definition. Immovable property it essentially includes all property which is unable to be moved. So we can't move, for example, land, unless we are very, very, very strong. And then obviously everything that is not immovable could be movable. And that is what all the other kinds of property that we have that exists. This is a nice way of looking at it. If you cannot move the property in which that you are examining, then we can call that immovable property, and if you can move it, then we call it movable property. This is something of a civil law tradition. However, in England and Wales, in the English law, we have this distinction not between movable and immovable, we have a distinction between real and personal. And the key distinction here refers to the idea of property rights being able to bind third parties. And so realty, the idea of real property, i.e. land, is capable of binding third parties, and such we describe it as real property. Personal property is not, and so as a result includes all of the other kinds of property ownership. It includes goods and chattels, it includes things like patents, like intellectual properties, it also includes securities such as stocks and bonds, debt and equity securities. And so as a result of which, we can essentially talk about the ability for third parties to be bound to a particular, to the rights of a particular type of property, which is, of course, where realty comes in, and then everything else is just described as personal property. But as I mentioned at the start of this lesson, the way in which you would study this at university would be as three clearly distinct modules. You would study this as land law, personal property law, and then probably intellectual property law. You may even describe this as 4 modules if we then talk about things like the law of corporate finance, talking about security ownership of bonds and stocks. But in terms of the distinction, you make a delineation between realty and personal property. But there is one key exception that exists here, an exception that is technically personal property, but which we're going to be studying in great detail in land law. And this is the idea of leases and the leasehold estate. The reason why this is the case, it is because, at least from a historical perspective, the lease in law was described as, or understood to be, a contractual obligation between a landlord and a tenant rather than a right against the land itself. And so as a result of this, you have this quite weird exception that exists where the lease can be viewed as something of a personal property rather than realty, and so it sort of stands out as an example of interest in land, which is personal property and not realty, despite the fact that leases are, of course, definitely within the remit of our study in land law, and we will be talking about leases in a lot of detail in future lessons' time. In this lesson, what I want to do is talk about the concept of estates in land. Now, we're going to essentially take an overview to the different kinds of estates which can exist within land law, in English law specifically. And the aim here is not necessarily to provide the context and detail of the various elements of conveyancing of estates and the concept of third-party rights over particular pieces of land and all these different things. Of course, those are the things that are going to make up the majority of our subject lessons when we look at unregistered and registered land as well as leases. Instead, we're going to just take an overview, so we have a better holistic understanding of what kind of estates in land exist, so that when we go into looking at the more complicated details of land law, we're going to have a better understanding, using this lesson, of whereabouts we are in terms of our understanding of estates. It's part of the final of our introductory set of lessons on land law and the nature of land ownership, and it's essentially going to talk about the different kinds of estates. So we're going to draw mostly our attention to the concept of the freehold estate in this series of lessons, and we'll talk a little bit about the leasehold at the end of this video, but of course the leasehold and the concept of leases is going to be a separate series of lessons in and of itself. So the first question is, well, what actually is an estate? Estates are the most important area of land law in the sort of modern context of the way in which we study, and an estate is simply an indication as to the period of time which a person is able to hold the land, is able to say that they have possession of the property. And so as a result of which, the types of estates would change from the common law with the enactment of the Law of Property Act of 1925, the LPA. And ultimately, we can think about a delineation between 2 major types of estate. You have, firstly, the freehold estate, and then you have, secondly, the concept of the leasehold estate. Within this, you have various different kinds of freehold estates, which we're going to get to in a second. And then, obviously, the leasehold estate, again, refers to a different amount of time for which you have the ability to claim exclusive possession over a piece of property. So beginning first then with the freehold estate, should I say, the freehold estate provides the most substantive rights of ownership in land. So if you have access to a freehold estate, whichever one that we're going to look at in this lesson, you have quite substantial rights over that particular property. We can divide the freehold into 3 major types of freehold. For the most part, when we talk about land law in future lessons, when we talk about registered and unregistered land, for example, we're going to be focusing almost all of our attention attention on the concept of the fee simple. That says free simple. On the fee simple. But we will touch on in this lesson what a life estate is and what a fee tail estate is as well. So the fee simple is effectively the absolute ownership of the land in question. So we say obviously that in theory we know that that land is owned by the crown, through the concept of tenure and all these different things like that. But in reality, if you have a fee simple over a piece of land, you are effectively the sole and absolute owner of that land in question. It has the theoretical application of basically allowing you to have an estate indefinitely for as long as you want, and to pass that down for however long you want. And it therefore means that you are de facto the owner of the property. So even though we say, and we like to qualify the fact that actually technically the land is owned by the crown, if you're the owner of a fee simple estate, you are basically the owner of that property for the most part. The crown isn't going to be able to just take that land from you. There are only a few circumstances where the law recognizes the true reality of the concept of the fee simple, i.e. that all land is technically owned by the crown. So there are a few examples and there are a few circumstances where the reality of the fact that it is owned by the crown actually plays a little bit of a part. So one of the examples of this is if an individual was to die intestate without any statutory next of kin, then the land returns to the crown bona vacantia, which essentially just means that land that is not owned by anybody. If somebody dies intestate, that means that they die without a will, essentially. Okay, so this is one of the only examples where we can see the influence of the crown and the crown ownership of a fee simple actually play a role in the possession of land ownership. So that's essentially one of the examples that we have here. We'll get onto this in future lessons time when we start to look at the law of succession and the concept of wills and estates. But for now, that is essentially the concept of bona vacantia. The life estate is relatively common, but is one that ultimately entitles one to the ownership of an estate for the duration of an individual's life. So whereas the fee simple allows you to have the ownership of an estate indefinitely for however long you want, the life estate entitles you to ownership for the duration of your life. And it technically means that you are more limited with the life estate than you are with the fee simple. But in terms of actually how this feels for an individual owner, it is still for the rest of your life. And so as a result of which you still have essentially exclusive and indefinite ownership of the estate, because when you die, it doesn't actually matter what happens to the estate, for you at least, but for everybody else it matters. But for the most part, the life estate is a little bit rarer than the concept of the fee simple. It does still exist in some circumstances, but for the most part, when we talk about the concept of freehold ownership, we are talking about the fee simple. Finally, then, we have the very rare fee tail that exists. A fee tail is known as an estate in inheritance, and what the fee tail does is entitle a family ownership so long as there is a continuation of the family lineage. So it essentially means that as soon as the descendants of the original owner dies out, then the fee tail will end. So long as there is an inheritance line that you can trace, and people will still be able to inherit the estate one after the other. That is what the fee tail is. Again, don't really need to spend much time examining it. We just need to, oopsie daisy. We just need to think about it very briefly, and then think about the fee simple in more detail in future lessons. So yeah, increasingly rare in modern land law context, but you can understand how it would be actually more common in a few centuries ago, when the concept of inheritance and the concept of the inheritance of land was a little bit more of an important concept. Finally, then, we have the leasehold. The leasehold essentially will give an individual exclusive possession of the land in question. So in terms of your rights in that land, they're very similar to that of a freehold, but it is only for the duration of a specific period of time, i.e. the duration of the lease. And so ultimately, whereas a freehold gives you potentially lifelong or unlimited access and exclusive possession, the leasehold grants exclusive possession for a limited time period. The leasehold may also grant you limited ability to do things with the land. So this will obviously be determined by the lease in question, by the terms of the particular contractual lease that exists. But in terms of the duration, it will be the duration of the lease in which you have exclusive possession for it. This is sometimes known as a slice of time. So you are given essentially all of the rights of a freehold in terms of the legal possession of that property, but only for a limited period of time. And so we'll get to this in more detail in future lessons when we actually make a delineation between the leasehold and the freehold in looking at the definitions of what a lease actually is, the key and the key characteristics and requirements for the existence of a lease, for example. Welcome back everybody to Land Law. In this lesson we're going to finish talking about the introductory elements pertaining to land ownership and the transfer of title and all of these different issues that we will examine in land law, focusing on the idea that there exists both legal and equitable rights within land. Now, this is very important. It's important that we spend some time doing this in this lesson because this will continue to crop up. This will continue to crop up when we talk about unregistered title systems, when we talk about the registered title system, when we talk about trusts of land and co-ownership and the way in which equity and legal rights actually interact with each other there. Equity is very important to understand the way in which land law essentially operates. So that's what this lesson is going to just take an overview of. And ultimately, this is really where land law is possibly the place where we see the clearest intervention of both law and equity. You maybe make the argument that trusts is another area where there's clearly a lot of equity influencing rules and procedures, but so too is land. These are the sort of the two main places where we can see the distinction between legal and equitable interests which exist. So as a very brief overview and a brief introduction, let's just take a view of what equity actually is at the start of this lesson. Now, the reason why this is brief is because we have already done a number of lessons already on what equity is, the history of equity and the maxims of equity when we looked at this in relation to the law of trusts. So when you do the law of trusts, for those of you who haven't done the law of trusts yet, who may not have any interest or any kind of inclination that you have to do the law of trusts if you're doing an LLB, that you will have to have an understanding of equity there. So go over to those lessons if you want a more detailed explanation. But for now, let's just do the sort of quick version at the start of this lesson. The concept of equity developed out of the early years of the common law, where essentially it was considered that the correct application of certain common law rules were considered to be unjust. It derives out of the arbitrary whims and authority that the monarch has in making in making decisions on the basis of justice, and so as a result of which it came to become delegated to the Chancellor, who then delegated it to his staff, which then turned into a court of chancery, which became its own separate equity court, if you will. So the principles of equity essentially step in to alleviate the seemingly unjust application of common law principles. That's where we get the phrase from. We get the phrase out of the Latin aequitas, which comes from the Roman law tradition of justice and fairness. So we are talking about justice and fairness. Despite as well, there are also canon law origins of the phrase equity as well, but we're not going to get into the etymology of the phrase in too much detail here. It's very clear from the early days of the Court of Chancery that this would be applied to issues relating to land ownership. So land ownership and the concept of land law and property law in this way was always going to see this interaction between legal rights and equitable interests in land. We then get the fusion of law and equity in the 1870s with the Judicature Acts. Essentially, before the 1870s, you have two distinct and separate jurisdictions. You have an equity court and the Court of Chancery, placed in Westminster Hall, I believe it was, and then you also have the normal, ordinary common law jurisdiction that exists as well. And these two jurisdictions were then fused, or allegedly fused completely, in the 1870s with the Judicature Acts. The reason why I say allegedly fused is because there's still academic debate going on to this day about whether or not the idea of true fusion has existed between the legal and the equitable interests or between the adjudication of law and equity, should I say. Intervention from a legislative perspective in relation specifically to land would then come with 1925 and the Law of Property Act, because what the Law of Property Act does is make it very formal and make it very clear the distinction between the legal and the equitable rights in land. Again, we will see, if you want more on the idea and the subject of equity, go over to our lessons on equity and trusts. It's another core module. If you're doing an LLB, you will have to study equity and trusts in some way. So as a result of which, you might as well go over and have a look anyway. But if you're somebody who is not studying an LLB, who's just generally interested in law, you should know that there is a separate series of lessons on specifically the concept of equity and the concept of trusts in the general form. This is a subject on land, specifically on land law. So let's think about the Law of Property Act 1925. What does it actually say? Well, what the Law of Property Act will be is a major legislative reform to the ways in which there are different types of interest in land and the types of interest that may exist in land, and whether those interests are legal or equitable. The Law of Property Act also makes a number of changes to pretty much every area of land law. So for those of you who are studying land law formally, you might be encouraged by professors or lecturers to get hold of a statute book, a copy of a land law statute book, and you will see that there's a lot of the Law of Property Act in those statute books that you need to have an understanding, a detailed understanding of how they operate, because we will get onto the Law of Property Act in a lot more detail as time goes on. But what the Law of Property Act does in relation to this specific area is actually reduce the number of legal rights in land and then outline the number of equitable rights which exist in land. So what it does is it clearly defines and delimits what the legal rights in land may be, and then essentially says that any other right that can exist can only ever be an equitable right, and therefore only has the ability to bind a purchaser from the perspective of an equitable interest. And that is going to be important when we look at registered and unregistered title, because essentially when we are looking at legal rights versus equitable rights, those interests depend, or at least one interest is weaker than the other, shall we say, because you have legal rights which will always bind a purchaser of title, but then not every equitable right may bind a purchaser of title. You may find that an individual is what is known as equity's darling, which we will get to in the next lesson. Section 1 of the Law of Property Act says the following, okay? It's titled The Legal and Equitable Interests, and it says that the only estates in land which are capable of subsisting or of being conveyed or created at law are an estate in fee simple absolute in possession, a term of years absolute, and then secondly, the only interest or charges in or over land which are capable of subsisting or being conveyed or created at law are an easement, right, privilege in or over land or for an interest equivalent to an estate in fee simple absolute in possession, or a term of years absolute, a rent charge in possession issuing out of or charged on land being either perpetual or for a term of years absolute. The reason why I'm being slow in reading this is because the language is so archaic, at least in my opinion, because it was passed in 1925. Or C, a charge by way of a legal mortgage, and any other similar charge on land which is not created by an instrument. Rights of entry exercisable over or in respect of a legal term of years absolute or annexed for any purpose to a legal rent charge. All other estates, interests and charges in or over land take effect as equitable interests. That's what we are looking at here, okay? So subsections 1 and subsections 2 outlines everything that could be a legal right, a legal interest in the land itself, okay? It's quite archaic, it's quite convoluted. We'll get through these and we will highlight them as time goes on. Some of them are quite easy to identify. So a charge by way of legal mortgage or an easement, these are obviously things that we can see and clearly identify as being legal rights. But then ultimately the point of this section and the point of reading to you section 1 aloud is that ultimately what subsections 1 and subsections 2 does is give you an indication of what essentially are the legal rights in land and make this a very limited definition. There is a clearly delimited number of things which can represent a legal interest, and that all other estates and interests and charges in or over the land that are not identifiable in subsections 1 or subsections 2 are equitable rights. And so as a result of which we have this delineation between the legal and the equitable rights in land. So this is essentially what it does. Section 1 limits the legal estates in land and the legal interests in land. So we have estates, such as the fee simple absolute in possession and the term of years absolute, which is sort of an old-fashioned way of essentially saying a lease, which we will get to, obviously. And then interests, so things like easements and profits, rent charges, rights of entry, and charge by way of legal mortgage. These are the sort of ways in which we can identify the legal estates and then the legal interests. The rest, everything else, remains equitable. Everything else is an equitable interest. And we'll get onto this in far more detail in future lessons' time. But for now, this sort of concludes the first major chapter on land law, looking at an introduction. The next set of lessons are going to be on unregistered title.